Hello, and thank you for joining us for part 2 of our 4-part Intellectual Property Basics series. This workshop series is being presented through a collaborative partnership between the Arkansas Small Business and Technology Development Center and the UA Little Rock William H. Bowen School of Law Business Innovations Clinic. I am Brett Harris, a Rule 15 student attorney at the Bowen School of Law.
And I'm Kim Vudin, Assistant Professor and Director of the Business Innovations Clinic at the Bowen School of Law.
The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials shared in this presentation are for general informational purposes only. Information presented in this presentation may not constitute the most up-to-date legal or other information. This presentation contains links to third-party websites and materials. Such links are only for the convenience of the attendee, user, or observer. UA Little Rock does not endorse the content of third-party sites.
In this presentation, we'll discuss the definition of a trademark, factors to consider in selecting a mark, common naming pitfalls, how to conduct a preliminary search, preparing or registering that application, and how to maintain your trademark.
To recap, trademarks are one of 4 major legal tools commonly used in intellectual property. For more information about copyrights, patents, or trade secrets, please view our other Toolkit videos on each of these topics accessible on the websites of ASBTDC and the Business Innovations Clinic.
Let's start with the pop quiz. True or false? Sounds can be trademarked. True. Sounds can in fact be registered for trademark protection. While this is not commonly done, some famous sounds such as the NBC chimes are in fact trademarked. On the other hand, Harley-Davidson recently tried to register the sound of their engines, but eventually withdrew its application due in part to the difficulty in registering sounds for protection.
Trademarked material is everywhere. In fact, it is difficult to conceive a single day where an individual does not utilize or encounter something protected by a trademark. Whether it be your favorite soap, favorite toothpaste, or even your favorite bag of chips, all of these products, logos, names, are likely protected by trademarks.
So, what exactly is a trademark? A trademark consists of words, names, symbols, devices, sounds, or any combination thereof. The ultimate goal of trademarks are to distinguish the goods and services of one particular source from those of another, and are used as a means of indicating the origin of goods and services. In short, trademarks are the tools that create brand.
In that trademarks are used to create a brand for goods and services, they are intended to serve as a means of consumer protection. Trademarks can enable consumers to easily identify their favorite brands and distinguish them from products made by others. Take, for instance, shopping at a supermarket. A shopper can easily identify her favorite brand of ranch dressing from a shelf containing several different brands due to the distinguishability of the trademarked logo. In short, trademarks try to prevent and punish free riders and copycats.
Likelihood of confusion is an often referred to standard measuring the degree of potential for a mark to conflict with another. This standard is based on numerous factors relating to what consumers will likely perceive. Thus, the primary question is whether consumers will be confused as to the provider of the particular good or service. A recently highly publicized example of consumer confusion arose when a consumer mistakenly purchased Gorilla Spray adhesive instead of Moco de Gorilla hair gel. As you can imagine, this mistake resulted not only in embarrassment but also potential damage to the consumer's hair and scalp. The consumer claimed that she made the mistake because both products looked similar and had similar names. As you can see above, both products do in fact have a similar color scheme and features depictions of a gorilla. In the context of developing a new mark, you should always remember that a likelihood of confusion can preclude the registration of your mark and can potentially lead to damages and/or injuries to consumers and existing mark holders alike.
The facts used to determine likelihood of confusion include the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression, the similarity or dissimilarity and nature of the goods as described in an application or registration or in connection with a prior mark in use, the similarity or dissimilarity of established, likely to continue trade channels, the conditions under which buyers to whom sales are made, impulsive versus careful purchasers, the fame of the prior mark, the number and nature of similar marks in use on similar goods, the nature and extent of any actual confusion, the length of time during and the conditions under which there have been concurrent use without evidence of actual confusion, the variety of goods on which the mark is used or not used, the market interface between the applicant and the owner of a prior mark, the extent to which an applicant has a right to exclude others from use of its mark on its goods, the extent of potential consumer confusion, and any other established fact probative of the effect of use.
Now let's talk about what makes a good mark and some things to keep in mind when developing a mark. In general, trademarks are evaluated in terms of overall strength and protectability using the Trademark Taxonomy scale. This scale is comprised of 5 different categories ranging from unprotectable to strong protection. As you'll soon see, each category requires varying degrees of creativity and inherent distinctiveness which correlate with the function of serving as an identification of origin. You'll want to keep this scale in mind throughout the process of developing your mark. The scale is loosely divided into 5 main categories. Each category receives a different level of protection under trademark law. The scale ranges from completely unprotected marks to strongly protected marks. And the 5 main categories are generic, descriptive, suggestive, arbitrary, and coined marks. The rule of thumb is to avoid creating a mark that is merely generic or descriptive. Next, we'll explain those categories in more detail. Generic marks are the weakest type of mark and are unprotectable. A generic mark consists of a term that is commonly used by consumers to refer to the product or service itself rather than the particular brand of a product or service.
While a mark may not be generic at the time it is created, it can become generic the more famous and widely used it is. For example, Bayer once held a trademark for the name aspirin, but over time consumers became so familiar with the mark aspirin that they began using it for all brands of the specific drug formulation, not just Bayer's. Because of this generic usage, Bayer lost its trademark for aspirin. Other famous examples of once registerable marks that have since become generic include shredded wheat, trampoline, and linoleum.
You may be asking yourself, how can I avoid my mark becoming generic? Well, the answer is that you need to take protective steps to prevent generic usage. This can be done through several different ways, including consumer education, strong enforcement of your mark, and strategic marketing of your product. Google serves as an excellent example of using consumer education to avoid generic usage, in that Google now refers to itself as a search engine and encourages consumers to refer to searches as being conducted through a search engine rather than using the term Googling. Jell-O and Kleenex both use strategic marketing by referring to their products as Jell-O brand gelatin and Kleenex brand tissues to indicate their specific brand.
The next category on the trademark scale is descriptive. Descriptive marks merely describe the goods or services, and because they are not distinctive or creative, descriptive marks are generally unprotectable.
Of course, there are exceptions. If a descriptive mark has acquired distinctiveness or secondary meaning, they could qualify for trademark registration. Keep in mind, however, that acquired distinctiveness is difficult to prove because it requires 5 years of continuous use of the mark and proof that consumers are familiar with the mark as intended by the person trying to register it. As you can imagine, this is something that's impossible to prove for newly created marks.
Consumer familiarity is often proven through consumer surveys, which can be time-consuming and very expensive. Essentially, these surveys would have to produce data on the beliefs and attitudes of consumers towards product concepts or names, and could be gathered through a variety of means, including consumer queries through shopping malls, telephone calls, and web surveys. The evidence would need to demonstrate that the mark has an acquired special significance so that the public has come to understand the mark as being associated with the producer of the products instead of being merely descriptive of the product itself.
Coca-Cola would be considered a descriptive mark because it describes the product from which it's created. However, it's established acquired distinctiveness to overcome being descriptive, and is definitely a registered trademark today.
On the other hand, some examples of descriptive marks that wouldn't qualify for trademark registration would be cold and creamy ice cream or pillow soft mattresses. Obviously, acquiring distinctiveness is no easy task, so descriptive marks should typically be avoided.
The next category is suggestive, which is the first category that is on the green portion of the scale. This is because the suggestive marks signify the first category that is generally protectable by trademark registration. Suggestive marks are comprised of words or phrases that allude to the type of product or service, but do not directly describe it. These marks require consumers to use at least a small degree of intellect to infer what the type of product is or service is, since it's not obvious. Because the exact goods or services are not obvious, suggestive marks do require some consumer education in order to create consumer brand awareness. An example of a suggestive mark is Netflix, which is the abbreviations of Internet and the movies combined together. Another example is copper tone sunscreen, which alludes to a tan skin tone. And yet another example is the Airbus, which refers to a bus that travels in the air.
The next category is arbitrary. Arbitrary marks have a common meaning that is completely unrelated to the goods or services. Because of this disconnect between the common meaning and the goods and services, more advertising and brand development is required to establish consumer brand awareness. It is as if you selected a word from a dictionary to brand a product completely unrelated to what the product actually is. Because arbitrary marks are so distinct, they are afforded a broad scope of protection. Some examples of arbitrary marks include Dove for chocolates, Dove for soaps, Apple for computers, and Shell for gas stations.
The strongest of marks are coined. Coined marks are letters, numbers, and/or symbols forming a mark that has no meaning outside the use of the mark. Because the mark is essentially created from nothing, coined marks have the highest degree of inherent distinctiveness from other marks and are given the broadest scope of protection. Some of the most famous brands in the world are coined marks. For example, Clorox is immediately recognizable to a cleaning product company. Other coined marks include Google, Rolex, Kodak, and Exxon.
Now that we've discussed the trademark scale thoroughly, let's briefly review the characteristics of weak and strong marks. Weak marks are not inherently distinctive because they are merely descriptive of the product or generically refer to the product itself rather than the source. Strong marks are inherently distinctive because they require a high degree of creativity to create and require time and money to build brand awareness. With these characteristics in mind, let's take this pop quiz. For each mark, please describe whether you think it is a weak or strong mark. Let's start with free conference call. Is this a weak or strong mark? If you said a weak mark, you are correct because it is merely descriptive of the service it provides. Next, Denver Mattress Company. If you said weak, you are correct because it is merely descriptive of the geography and goods it sells. Next, Printar. If you said weak, you are correct because Printar is generic and merely descriptive in referring to the product itself rather than the brand. Next, Gatorade. If you said strong, you are correct. Gatorade is a coined mark that has no ordinary language meaning. Last, Firefox. If you said strong, you are correct. Firefox is an arbitrary mark combining the words fire and fox, which have no relation to technology or internet browsers.
Now, let's discuss some of the most common mistakes when developing a mark for registration. As a general rule, you should avoid the use of personal names being used in your mark. This is because personal names cannot be trademarked without acquired distinctiveness. As we previously discussed, acquired distinctiveness is not easily established. To establish acquired distinctiveness, you must show prior ownership of similar registrations, at least 5 years of continuous use of the mark, and actual evidence of consumer brand awareness. Here you may notice that we have pictures of Adlon Hotel as well as a nightclub. Adlon Hotels are a fairly well-known brand in Europe and have acquired distinctiveness. However, Adlon Nightclub could not obtain registration of its name because in the US, Adlon is a last name. Specifically, Adlon Nightclub could not establish any common language meaning of Adlon beyond being the last name, a last name, and could not prove acquired distinctiveness.
The next common naming pitfall is in the mark being geographically descriptive or geographically deceptive. Here, geographically descriptive means the mark includes a geographical reference to the place of origin of the goods or service. A geographically deceptive mark includes a location name that would lead consumers to believe the product is produced there, but in reality it is not. Here we have a picture of a Western wear clothing store in reference to the mark Denver Western being geographically deceptive to obtain registration. Another example of a geographically deceptive mark would be if the mark Icelandic glacier water was actually bottled and distributed from Little Rock, Arkansas's tap water.
As we've already discussed, use of generic terms in a mark is quite problematic. You should make sure when developing new marks that consumers do not already refer to your goods or services by the mark you're hoping to register. This is unfortunately common, such as in the case with escalators, trampolines, cellophane, and even thermos.
Yet another common pitfall arises from translation issues. This pitfall is really twofold. First, the mark translates negatively or inappropriately in other languages, and second, the English translation conflicts or creates a likelihood of confusion with existing marks. The translation of your mark generally to other languages should always be considered. For example, Chevrolet encountered this problem with their Chevy Nova, which translated in Spanish to no-go. It goes without explanation that nobody wants to purchase a vehicle that is a no-go in getting them to and from their travel destinations. Another example of the second point is a hypothetical in which a French general retail store named Cible seeks registration in the US for a chain of stores selling a huge variety of household items. In English, Cible translates to Target, which is a registered trademark in the US for such a store. Cible would be prohibited from trademarking its brand in the US.
Last in our list of common naming pitfalls is selecting a mark that's already in use by somebody else. While this may seem rather obvious, it's nevertheless a common issue for many individuals seeking new registrations. This mistake is mostly made because individuals think that they had to be super creative in coming up with an idea that nobody else will have had the same, idea. Unfortunately, this is often not the case. For example, there was an issue with competing Don Donuts brands where one Don Donuts had several brick-and-mortar storefronts in a relatively small regional area, and the other was a store brand of donuts produced by a national grocery supplier. A general best practice is to start out by conducting a basic internet search of your mark to ensure that it's not in obvious use already. You'll want to do this before you spend your time and money moving forward with the mark that ultimately might not be viable for registration.
It's time for another quick pop quiz. Are the following marks examples of potentially good trademarks? Why or why not? First, Yellowstone Healing Waters, bottled from a City of Little Rock municipal water. This would not be a good mark because it is geographically misdescriptive and accordingly would be deceptive to consumers.
Second, QWERTY keyboards. QUERTY are the first letters from left to right on the top row of the standard American keyboard. Because the term QWERTY is generally used to describe the actual type of keyboard configuration, it would be merely descriptive and would not be a good mark.
With all of the discussion regarding registration, you may be asking yourself, how do I determine if my mark is registerable? Let's start by walking through an overview of the general process of conducting a preliminary availability search.
The overall process of checking to see if a mark is not already in use by somebody else can essentially be broken down into 5 steps. The first step is arguably the most difficult, which is developing a potential mark. The second step is to determine the classes you want your mark to be protected within. The link provided in Step 2 will direct you to the USPTO class manual, which you can use to determine which classes your goods or services fit within. Here, it's important to search for broad terms that are commonly used to refer to your actual goods or services and not your actual mark itself. Also note that your goods or services may fit within more than one classification. Step 3 is to conduct a search comprised of your potential mark using an internet search engine. This basic search should give you a good idea of any potential marks already in use that are similar to your potential mark. Step 4 is to conduct a test search on the USPTO website. TEST stands for Trademark Electronic Search System. You most likely are best equipped to use the basic search function, which is recommended for new users to the system. In this search, begin by searching 1 to 2 main words in your mark. For example, if your potential mark is Half Moon Apothecary, you'd want to search Half Moon instead of the full mark to see any similar registrations. The last step is to review all of your findings from your internet search and test search to see if you see any potential for likelihood of confusion with existing marks. It's important to note here that similar marks may be used if they're in separate classes, so long as they are not close enough as to confuse consumers.
Now let's walk through a basic preliminary trademark availability search. For purposes of this demonstration, we will be seeking trademark registration for the mark Half Moon Apothecary. Half Moon Apothecary makes and sells artisan soaps. Now that we have our potential mark established, let's begin with step 2, which is to conduct a quick search engine search of our mark to see if it is already in use by somebody else. Let's begin by searching Half Moon Apothecary. As you can see here, the first result is for a Facebook business page called Half Moon Apothecary. When I click the link, I see that Half Moon Apothecary is a clinical herbologist. And scroll through to see what products and services or goods and services are available on the page. And I'm not seeing soaps, so likely I would initially think that this will not be confusingly similar to artisan soaps. However, I need to return to the search results and continue looking at the additional listings. Here again, we have an herbologist service with a similar name. And returning back to the search engine search results, I'm not seeing any other listings that might indicate that the mark is already in use. Next, we need to conduct a test search on the USPTO website to see if any confusingly similar marks are already registered. From the test landing page, select the basic word mark search, which is recommended for new users of the database. Now you are ready to enter your search terms. Generally, you should identify one or two of the most important words used in your mark for your first search to yield the most applicable results. Here, I suggest starting out with the search for half moon to return all registrations containing the word half moon in it. Once your search results appear, look in the word mark column for marks that are similar to yours. Here, I immediately see Half Moon Bay Soap Company as a listing. So I will click it to obtain more information. After clicking the serial number, you will be directed to a page that provides an overview of that mark's registration. Here, pay special attention not only to the mark itself, but also the goods and services and classes in which the mark is protected. As shown here, Half Moon Bay Soap Company is protected under Class 3 for cosmetic bath salts, body scrubs, and cleansing creams. At this point, I need to determine the appropriate classes in which Half Moon Apothecary's goods could be registered. To do this, start by conducting a search of the Trademark ID manual. To begin your first search of the Trademark ID manual, you should think of potential search terms that are commonly used to refer to the types of goods or services for which you're seeking registration. Here, we know that Half Moon Apothecary makes and sells artisan soaps, so our first search should be for the term soaps. As you can see, this search yields 126 records or results. Next, you need to begin reviewing the results to find any descriptions or notes that closely match your goods or services. Once you identify similar listings to your goods and services, take note of the first 3 digits of the term ID shown on the leftmost column. These 3 numbers tell you the class in which the particular listing is housed. Here, note that several descriptions match Half Moon Apothecary's products, including bath soaps, cream soaps, and liquid bath soaps. All of these listings are housed within Class 3. However, if Half Moon Apothecary produces antibacterial soaps, this type of soap is housed within Class 5. This means that Half Moon Apothecary could potentially seek registration within both Class 3 and Class 5. Now that we have identified 2 potential classes to seek registration within, we should compare our prior search results from steps 2 and 3 to see if those results are within the same classes, Class 3 and Class 5. As you may recall, Half Moon Bay Soap Company's registration is within Class 3. Unfortunately, because this mark is similar to our mark and is registered in the same class as our mark would be, it is likely that our mark Half Moon Apothecary would not be granted registration within Class 3 due to a likelihood of confusion with Half Moon Bay Soap Company.
So what do you do after you've conducted a basic search? Well, now it's time to consider what evidence you will use to demonstrate use of your mark in commerce. But first, I want to go over a couple terms. In trademark law, the words in commerce mean sales and/or transactions across state lines, otherwise referred to as interstate commerce. Also, the word specimens refers to the evidence presented that show the mark in actual use in commerce. Specimens may be product labels or tags on the products available for purchase, websites, and even certain advertisements. You must submit at least one specimen per class in which you seek registration.
Let's take a closer look at specimens to see the actual examples. Starting with the Keurig stainless steel travel mug, you can see that the mark Keurig is prominently displayed on the actual product and that this product was actually available for purchase in a retail store. Next, we have the Procter & Gamble website showing Tide laundry detergent available for purchase. It is important to note that website specimens must include the URL and the date of access in order to be accepted. Notice that in both specimens it is clear that the products are for sale.
It's time for another pop quiz. For this quiz, assume that the specimen on the left, the t-shirt with the word specimens on it, is for a company named Specimens. Specimens provide DNA sequencing services. Assume that the mark on the right is the proposed specimen for a company called Wellness Station, which provides masks and hand sanitizers. With these assumptions in mind, are the specimens pictured here suitable? Neither of these examples would be acceptable specimens given the facts at hand. Specimens, as depicted on a t-shirt, would be acceptable if the ban were for goods and services such as t-shirts. However, as used by the DNA sequencing company, it's for a service. The Wellness Station is unacceptable because it's a digital rendering and therefore does not show actual use in commerce. The takeaway here is that a specimen needs to depict the product in commerce. Just a photo isn't enough. There needs to be some evidence that the good or service is available for sale across state lines.
So what should you do if you aren't up and running and don't have specimens yet? The short answer is that you cannot file for trademark registration without supporting specimens. So you should start considering and making plans on how you plan to demonstrate actual use in commerce so that you may seek registration at a later time.
Of course, there's an exception to every rule. If you're not ready to file for registration because you're not up and running and you have no suitable specimen, you might be able to file an intent to use application. However, generally this is not recommended unless you're absolutely certain you will use the mark and the mark will yield a fruitful return for increased filing costs. You must pay to register an ITU, which then reserves a mark for a 6-month period. You must use the mark in commerce in that 6-month period. Once you've done so, you must file your registration and pay fees once again. Thus, it's duplicative of time and money as opposed to just filing when you're ready.
So now you have conducted basic research on availability and prepared your specimens. Now you are close to being ready to file your registration and should seek assistance from legal counsel. Your attorney will collect all of the information and double check to ensure everything is good to go with your application prior to filing it on your behalf. While it seems like a straightforward process, if your application is not perfect, the trademark examiner will expect you to answer a number of questions using the somewhat unwieldy USPTO database. The questions are asked through letters that are written in legalese and often require an attorney to understand what the question is.
The overall cost of obtaining a trademark is relatively low compared to other IP tools, such as patents. You should expect to pay anywhere from $500 to $2,000 per registration, depending on the complexity of the mark and the number of potential conflicting marks if you file with the assistance of an attorney. The current USPTO filing fee ranges from $250 to $350 for each class in which you seek protection of your mark, which is what you would pay if you chose not to hire an attorney.
After filing, a USPTO examining attorney will review your application for a likelihood of confusion with existing marks and to identify any potential defects within your application. Once potential issues are resolved, your mark will then be published for opposition, which is a 30-day period which any party may object to the registration of the mark. If there is no opposition to your registration, then your official registration will be granted. The entire process takes around a year to a year and a half on average.
After you receive your official trademark registration, you should use the mark in commerce exactly as it appeared on your application for registration. Actual use is critical because trademark registration can be considered abandoned if you fail to continually use your mark in commerce. This means others could use that mark without violating your trademark. You may also begin using the registered trademark symbol with your mark if you wish to do so, but that's not a requirement. One of the most critical things to do beyond using your mark is to file the applicable declarations of use between the 5th and 6th year and 9th and 10th year of registration. After that, you must file the declaration of use every 10 years. Once you get your trademark certificate, it's a good idea to mark your calendar as to when you should file that declaration stating that you're still using the mark.
We have covered a lot of material throughout this presentation, so now let's end things by taking a look at some of the important takeaways from this presentation. First, you should try to pick a mark that is as counterintuitive to consumers as possible. For example, think of the name Apple as used in the technology and computer company field. Second, you should avoid using your personal name in marks. Third, you should make sure you are not using somebody else's mark or a mark that would be confusingly similar to someone else's mark. Last, use your mark as often as possible and in as many ways as possible. Not only is this good branding advice, but it also strengthens your ownership of the trademark. You should be using your mark consistently on all social media accounts, your website, and all printed materials.
We hope you've enjoyed and learned from this presentation. For more specific information about copyrights, please visit copyright.gov. For more information about trademarks or patents, please visit uspto.gov. If you'd like more information or connect with the Arkansas Small Business and Tech Development Center or the Bowen Business Innovations Clinic, please follow the links listed here.